All right. Thank you for joining us to talk about DFARS, the Defense Federal Acquisition Regulation Supplement, and all of the fun cybersecurity requirements that come along with it. Please let me know if there are any audio issues. You can use the chat function on the sidebar. And as we go through, please feel free to enter any questions that you might have within the sidebar function. I'm going to periodically have a look at that list and attempt to answer any questions as we go. I've also reserved some time at the end to talk about questions, anything that comes up. OCD Tech is the IT audit and cybersecurity division of O'Connor and Drew, which is one of the oldest accounting firms in the Northeast. We're actually about to celebrate our 70th birthday. We have a long history on the accounting side, going back in a number of industries. We're involved in regional organizations like the Massachusetts Institute of CPAs, the AICPA nationally, Cloud Security Alliance, as well as the National Defense Industrial Association. On the OCD Tech side, we operate in a wide number of industries, especially defense and aerospace, as we're going to talk about today. We offer a wide range of services, specifically with relevance to today, the NIST cybersecurity framework evaluations, NIST 800-171, which we'll dive into in detail today, as well as a whole host of other services. And briefly about me, I'm a senior IT audit manager at OCD Tech. I lead the DFARS line of service, and I've got about 18 years experience in IT and IT risk management. I've sat on both sides of the table, so I've been operationally in charge of IT departments, as well as my current role as an auditor and an assessor, an advisor to organizations. Okay, so quickly about today's agenda. We're going to cover what DFARS is, specifically the Clause 7012, a little bit about the history of it, what its implications are, what it calls for, and who is subject to the clause. We're also going to talk about probably the most important piece, and that's how to comply with the requirements in Clause 7012. There's some specific things you have to do, and some best practices, and we'll cover that. If you missed the deadline, which was 12/31 of last year for compliance, what should you do now? There are some serious consequences of non-compliance, so we want to make sure that those get across. In addition, if you're new to working with the DoD, or maybe you have a new contract where you're seeing this language, that Clause 7012, for the first time, we'll talk about what you should do. There's some clear and urgent activities that have to be undertaken when you're subjected to that clause. And then lastly, we'll talk about sort of the costs of compliance, with the caveat that they may vary widely depending on the size and the complexity of your organization. Okay, jumping in. What is DFARS and Clause 7012? Well, DFARS, as I said, it's the Defense Federal Acquisition Regulation Supplement. It's a sort of a subset of the FAR, the Federal Acquisition Regulation Supplement, and it basically it's a guideline that establishes some ground rules in doing business with the federal government, and here specifically with the Department of Defense. It's sort of a series of requirements, regulations, and how to interact and how to do business, how to sell your services to the federal government, and how, and from their side, the rules of the road in terms of buying services from third parties. A few years ago, going back to 2013, there was a concerted effort to focus on the security around a certain type of data that vendors would store and process in performance of a contract. And there's this category of data it's not classified, that's a whole other animal, This is unclassified data that the Department of Defense is very interested in protecting, as, depending on the type of data, it would do some kind of damage should it get out to the public domain. So, it's not classified data, and it's not, publicly disclosed data. It's sort of this middle category of, you could call it sensitive, you could call it confidential. It's information that's unclassified, but the Department of Defense wants to protect it. They call it covered defense information, and we'll go into a little bit of detail in terms of what that is in the next few slides. But this effort started in 2013, but it really took shape in 2015 when Clause 7012 was updated to reflect the NIST Special Publication 800-171 requirement. And fear not, we're going to go through in detail what all this is. There's a lot of jargon, there's a lot of specific terms, but we'll unpack this a little bit. But this is just a high level. So basically, the government, and specifically Department of Defense, has this category of information that they're interested in protecting that is typically residing with third parties, with vendors, primes and their subcontractors. And they were interested in laying out a framework, some guidance for these third parties, for these vendors, on what type of security controls they need to establish in their organizations. Now, initially, there's a framework called 800-53, and that is a very large framework that sets out some security guidance, but really it was geared towards federal information systems. And that really wasn't a good fit for private organizations. The terminology is different, the size and scale is different, and oftentimes the level of protection needed is a little different. So, in a lot of cases with the government, they're looking to establish a higher security bar than might be needed with third parties, with vendors, private companies possessing, unclassified information. So government recognized that 800-53 wasn't a good fit. So that's when we saw the development of 800-171, and we'll unpack what that is in the next few slides. There's also a requirement in Clause 7012 for the establishment of a cyber incident reporting capability. And in brief, that means if there's an incident on your network, as a third party contractor that does business either directly or indirectly with the Department of Defense, if there's a cyber incident that involves covered defense information, you are required to report that directly to the Department of Defense within 72 hours. So that means you need to have the capabilities already in place in order to do that. And, it might sound easy, but really when you think about it, you need the technology in place to identify a cyber incident in progress, ideally be able to stop it, but also you need the capabilities to aggregate the log data in order to bundle that information up, because the DoD is interested in basically, 90 days of your information from the point of compromise. So you do have to have, a certain level of technical sophistication in place. So they're very interested in, across the third-party landscape, identifying and investigating cases of, what they call cyber incidents. Presumably to see whether there's any sort of pattern of attack. There's a whole concept of advanced persistent threats, state-sponsored threats, and covered defense information is absolutely a target, as is obviously classified data. Clause 7012 also established December 31st of 2017 as the deadline for compliance. And we'll talk a little bit about what compliance means as we go through. And this is really geared to be a self-assessment activity. So a lot of organizations that we work with are a little confused by this at first. They'll call us and they're looking for a certification. And we really have to tell them there is no certification exercise. You're self-assessing and you're self-attesting to either the DoD or to your higher up in the contracting chain that you are compliant. and you know, we want to be honest when we say that, but it's a self-assessment activity. And as of right now, there's no audit function, you know, from DoD. There are some mechanisms for enforcement. We'll talk about that, but it is largely a self-assessment activity. Okay, so briefly, the history, I kind of covered this at a high level, and I won't go into the detail on this slide here, but this just gives you a sense of where this started from and where we are today. You know, I do hear from people that they're surprised by this. They weren't aware of it. It has been out for quite a while. You know, maybe you could say that DoD didn't do the best job of shopping this around and getting the word out there. But these requirements, in at least their earliest form, have been out, you know, since November of 2013. So this framework has been out there since 2015, the NIST 171 framework. And, you know, many organizations got out in front of this, you know, especially the big primes, your household names, started these compliance programs, you know, in some cases back to 2014. So it's been out there a while. And because of that, the DoD is not very tolerant of noncompliance. So we'll talk a little bit more about that. Okay, so this, the DFARS 7012 clause deals with covered defense information. And this is a broad category of information that is comprised of many different subsets. So it's comprised of controlled technical information, which may be labeled with certain distribution statements. So if you're used to working with the DoD, you're probably used to seeing distribution statements. So it's distribution statements B through F. It's comprised of critical information, which admittedly is a vague category, but that could pertain to operations security, which, while not classified, is definitely something the DoD is would not be keen on seeing leaked, you know, out to the public domain. So that needs to be protected. Any information that's export controlled is considered covered defense information. And then, you know, there are some broad categories, you know, the other bucket that could be considered covered defense information as it pertains to privacy or proprietary information. Now, we'll talk a little bit about information labeling as we go through, but really, depending on where you are in the contracting chain, this information, you know, every member of that contracting chain is required to make sure their information is properly marked. So CDI should be labeled CDI, export control or ITAR should be labeled as such. In cases where maybe you're subject to the 7012 clause and the information you're processing or possessing isn't marked, you should definitely seek to clarify with your contracting officer, either at the DoD or at the primes, or, you know, you're higher up in the contracting chain. You should seek to clarify what information that you're possessing is considered CDI, because that really is what you need to build your control set around, and that's what you need to use to as the center point to implement the 110 controls in 171 that we'll talk about. So the NIST Special Publication 800-171 was produced around 2015 as a better framework to use for private companies that store and process covered defense information. Initially, you know, there was that framework I'd mentioned earlier about 800-53, which is a very large, unwieldy, and largely federal information system oriented framework. Not a good fit for private companies. So the powers that be at NIST, which is the National Institute of Standards and Technology, they produce a wide variety of best practices on all areas of IT and IT security. They produced a kind of a distillation of the NIST 800-53 controls with some controls from FIPS 200, which is another information security framework. But they eliminated the controls that were in those two, FIPS 200 and 800-53, eliminated control requirements that were specific to the federal government. And what they were left with was basically a series of best practices that were a reasonably good fit for private companies and that could provide adequate security over covered defense information. The 800-171 framework is comprised of 110 security controls split across 14 families. And the wording is, some people call it vague, and some of the pushback against the framework is it's not very specific. And when it was initially released, there was really no implementation guidance. But from the NIST perspective, they wanted to make sure that there was enough wiggle room in the control language so that you could have your Raytheons, your Lockheeds use that framework, as well as maybe a metal shop is the example I use here, who might be 4 organizations down on the contracting chain. There's enough room for interpretation that you could potentially scale that solution to be appropriate for Raytheon or also to be appropriate for the metal shop. So they deliberately left it vague, and that's, of course, it's flexible in that sense, but it's also difficult, especially for smaller organizations, to determine how best to comply when that control requirement is, pretty vague, but we'll go into that. So as I mentioned, the control framework here is spread across 14 control families. These are largely derived from that NIST 800-53 framework, but they're split across pretty much your best practice control family areas. So obviously we want to touch on access control, how you protect access to your systems. Awareness and training covers how security conscious your staff, your IT administrators are. Audit and accountability speaks to the organization's ability to gather audit logs, to retain them, and also to be able to kind of dig through and synthesize information out of that data and make sense of it, patterns of potential system compromise. Configuration management speaks to the organization's ability to proactively build secure baselines, to document those, make sure your systems out of the box are built and provisioned securely. Identification and authentication, that sort of speaks for itself. The controls there speak to the ability of the information systems to uniquely identify users, to authenticate them using secure means. And one of the big ones here is multi-factor authentication. That tends to be a big tripping point for smaller companies. Incident response, again, this is a fairly obvious one and actually has some play into the cyber incident reporting process. But incident response is the organization's ability to not only recognize an incident is in process, but also have a well-vetted process to react to an incident, to be able to, stop the incident in progress, contain it, and go about a process that will gather and save any forensics data that's associated with the incident, and be able to restore any systems that have been impacted. Maintenance largely speaks to patching, although there are some other controls there, but keeping systems up to date and protected. Media protection is another area. Think about portable devices, be it portable hard drives, USBs, CDs, that sort of thing. How do we protect those? Do we encrypt them? If we're putting covered defense information on portable media, we need to think about how we protect those. Are the drives encrypted? Are they locked in secure locations? Are they assigned to an owner? That sort of thing. Personnel security and physical protection sort of go together, but these areas are about protecting people and facilities. Risk assessment and security assessment sort of pair, and that's kind of proactively looking at, from a process and infrastructure perspective, being sort of ahead of the curve on assessing whether the CDI that you have is at risk in your current configuration, being aware of your vulnerabilities, potentially performing vulnerability assessments against your infrastructure, documenting on a regular basis areas that need to be improved and addressing those appropriately. That's kind of the gist of those two. System and communications protection and system and information integrity really kind of speak to the point of making sure that all inbound and outbound communications, between relevant parties are protected, encryption in transit, that sort of thing. And information integrity could be a number of things depending on your configuration, but it could be speaking to integrity checking mechanisms, the access control methodologies you've implemented to protect your data, and to ensure that the integrity of the CDI is not impacted by, say a less than ideal configuration. So these are the 14 control families, and within these in total are 110 security requirements. So it's a fairly sizable framework. So now the question, are you subject to DFARS 7012? Well, there's a pretty easy rule of thumb here, really two ways to determine whether you are. The most obvious one is if you know you have covered defense information in your presence, then yes, you are subject to it. All covered defense information must be handled in accordance with DFARS Clause 7012. Another easy way, and most often this is how people know, is you'll see this language in a contract, task order, purchase order, whatever activity you have from either a prime or DoD directly, prime, or someone else in the contracting chain. It will reference DFARS Clause 7012. And I've seen the wording in a number of different ways in terms of how that's phrased, but you will see that language in some way. I've seen it, oftentimes on purchase orders, but on contracts as well. And another way, really, just to clarify is, depending on where you are in the contracting chain, talk to your contracting officer. Who are you getting this contract from? If you suspect there's CDI in association with the contract and performance with the work, clarify that with your contracting officer. Err on the side of caution. Everybody involved in this process is required to mark the data and be aware of the data that they're holding. So they should know. They should be an informed point of contact. Well, how to comply? This is a tough one, right? What does compliance look like? Well, in short, the process at a high level is straightforward. It's when we get down to the nitty-gritty that it can be difficult here. But the process of compliance is simply the exercise of reviewing those 110 security requirements to see kind of whether or not you have it in place already. I'd say most organizations do not have all 110 in place, but certainly there are some controls for everybody that already are. But really it's reviewing that list to see whether you have it in place, whether you can meet the spirit of the requirement through a policy, written policy, or a process or procedure guideline, or whether you need an implementation, of some kind, be it software, hardware, configuration changes. It's that doing that initial gap assessment. The size and scale of your organization will determine a lot. Obviously, that has cost implications. If you're running an organization of 100,000 employees, the cost of compliance will probably be, very significant. If you're running a smaller company, there's definitely going to be a cost as well, but you might be able to get away with more of a policy or procedure oriented approach. There is that in room for interpretation and scalability in the framework. One important note, though, is that you can't deviate at all from those 110 requirements without explicit authorization from the Department of Defense. If there's a control in there that maybe you don't like, or you don't think you can meet given your current maybe limitations, you actually need to write in to the Department of Defense and request an exception, basically. And you have to write a justification as to why you don't believe the control should apply to your organization. You do have to provide some kind of justification for it, and they will review it. They'll come to their opinion, and they'll get back to you. But absent that, you can't deviate at all. You have to at least make an attempt to comply with it and track it in some way. So we'll talk about the specifics of the compliance process and how we track things that are not currently in place but are on our roadmap. So once you've gone through the 110 controls and had a quick assessment of whether you think they're in place already and whether they are feasible or what, you want to start documenting this in what we call a system security plan. And if you've worked in the federal government sphere, the Department of Defense sphere, you'll be familiar with a system security plan. And there are templates out there, that you can find them on the FedRAMP website. But system security plan is it's a type of document that is common in the federal information systems world, and it's simply a document that describes your IT environment. And you can break it up to, speak to specific applications themselves, or you can do an organization-wide system security plan. You can slice and dice in any number of ways, but the intent really is that for this particular DFARS 7012 clause, you want a system security plan that describes in detail the quote-unquote system in play. And, we'll use an example of a small to medium-sized business. Maybe the network is simple enough that the organization has chosen to make all of it compliant with 800-171. So your system security plan will essentially describe your entire IT environment. We'll talk about system boundaries, and that might be the perimeter defenses, the network perimeter, operational environment. We'll talk about your end users. We'll talk about how they interact. Are they using desktops physically in one location? Are they using laptops? Are they remote operations? Are they on the road? That sort of thing. Kind of the demographic information. We'll get into a little bit about network inventory, hardware inventory, application inventories. We'll talk about control implementations. Now, this is where the rubber meets the road here for DFARS 7012. Those 110 security requirements need to be documented in your system security plan in the context of how you have implemented them. So I have a screenshot a little later on from our DFARS system security plan template, but really they're looking for that your specific implementation of these requirements. So if there's a requirement that speaks to the need of multi-factor authentication, what you need to do in your system security plan is document how you've implemented that control. So the specific requirement for your organization. So they're not looking for a checkbox, yes, we did it. Yep, no, that's not going to work. They want to know in narrative form how you've implemented that control. So it has to be very specific, very detailed, and tailored for your specific environment and how you've implemented it. Another important aspect to your system security plan is going to be talking about any system or network interconnections. Do you work with partner organizations? Is your network federated? It's documenting sort of what are the boundaries of this universe that are in scope for this system security plan. And the idea is that the system security plan, or SSP as I'll call it from now on, needs to be detailed enough and written in such a way that that a person reading it with no knowledge of your organization will be able to review it and come to some assessment of whether or not you have implemented the controls, or they need to sort of make that risk-based judgment on, to be honest, whether you should win a contract that might involve CDI. Are your controls up to the level where you can adequately protect that information should you win the contract? And that's really the goal. And we'll talk about how these SSPs are going to get used really starting now at the beginning of 2018 and forward, now that we've passed that compliance deadline. So the SSP is going to be your primary way to demonstrate that you are compliant with 800-171 and all the requirements of the 7012 clause. So here's just a screenshot from our System Security Plan SSP template. Now, the 14 control families are broken up into specific control numbering. So this is from the Media Protection Control family, which is 3.8. The third control of that section, so 3.8.3, the requirement is to sanitize or destroy system media containing controlled unclassified information before disposal or release for reuse. So our approach, again, going for a very detailed implementation statement, is to document in narrative format how the company in question has implemented this control. So in this case, this company has written a controlled unclassified information policy, which details all requirements for the secure disposal of controlled unclassified information. Okay, it talks about how we wipe the data, make that previously written data unrecoverable. Physical media like CDs, CDRs will be destroyed and obviously can't be reused. And any printed CUI or CDI will be shredded. Okay, that's a very specific control implementation. We talk about the status, so if it's not yet in place, if it's something we're working on, we would put it, partially in place or planned, some status like that. But this is sort of how they're looking for you to interpret that control statement and come up with your implementation approach. So really, nobody is fully compliant out of the gate. The 110 control requirements in a lot of cases are very detailed and not something that you would typically see in a small to medium business, and even some enterprise Fortune 100 organizations. There's a requirement to have multi-factor authentication for local administrative access, for remote access, and a lot of organizations don't have that. And there are many other controls as well that maybe they just call for policies and not necessarily a technical implementation, but many organizations don't have policies that cover every facet that are being called for here. So there's definitely going to be a situation where you do not have all of the controls in place. And what the regulation is calling for is the creation of what they call Plan of Action and Milestones document, or a POAM. And that's your action list. That's your to-do list. You want to use this document as kind of your prioritization of compliance. This is going to be your roadmap. You want to populate this, and the spreadsheet is really the best format for this because you can filter it, sort it. You want to be living and breathing in there and spending, kind of the majority of your compliance time in this document. Spreadsheet's a great format for it. But the intent of it is to demonstrate, should somebody ask that, maybe it's your higher up in the contracting chain. The intent of this document is to be able to demonstrate on short notice that although you've got a compliance effort underway, you're not 100% compliant yet, but here's the POAM that shows whoever wants to review this document that you are aware of all the areas that you're falling short. You have a documented plan to address those control deficiencies. You have a measured and accurate plan, timelines, milestones to address that and to remediate those controls. And you've got point of contact assigned. You have a plan to become compliant. That all needs to live in the POAM, and it needs to be kept up to date as often as you make changes, in the environment. So that's the system security plan. Should also be kept up to date, but really, as you go through that, you'll find it's a little bit more of a static document. You create it up front, you realize you've got a lot of work to do, you populate your POAM, you're living and working day to day in the POAM as things get updated, as you achieve milestones. And then you can find, okay, we've implemented a control, then you go back to the system security plan and you change the language there. But really, it's the POAM that will be your priority list and your action list while you're in the compliance phase. So a good POAM includes at least the following areas here: a control number reference. You want to tie back to which of the 110 controls you're referencing. A summary of the findings. So, why aren't you compliant? Maybe you don't have multi-factor authentication, or maybe you have default passwords for some accounts, or maybe you don't have any logging for your firewalls, for your key systems, for maybe, your Active Directory, what have it. Maybe logging is turned off. That's a finding. You want to document what it is that, in what way you're failing the control requirement. You want to name a point of contact. You want to identify resources that are required. Is it money? Is it time? Is it a combination? Is it hardware? Is it, what is the resource, or what are the resources that you need to remediate? For maybe more complicated control requirements, you want to identify milestones. So maybe, for multi-factor authentication, that's a broad category. So maybe you want to break that up into putting on multi-factor on your VPN solution, putting it multi-factor on your Active Directory, or maybe privileged, servers, administrative servers, management servers, that sort of thing. Break it up a little bit into more achievable pieces with completion dates. And then you want to have a scheduled final completion date for all facets of the finding. And then, one thing that helps that I've seen is just a current status, a notes field even, where somebody can open the document and quickly get up to speed on where things are at that moment. And again, it really needs to be kept current at all times. That's, a good POAM is up to date. It's something that you're in pretty much every day as you go through your compliance efforts. And there's a bit of a misunderstanding, and maybe this is the fault of the DoD through this process, but initially there's an understanding that compliance by 12/31/17 meant 100% implementation of those 110 requirements in NIST 800-171. There wasn't really, it wasn't clear, and if you read the actual regulation, that clause 7012, it's not clear. So, for a long time, everyone said, well, we really need to get to 100%. But the DoD recently, I want to say in October of 2017, came out and said, we consider compliance by 12/31, at least, compliance to be a credible and honest effort to stand up a 171 program. And that would be demonstrated by a detailed SSP and a fully populated POAM document with realistic timelines, realistic milestones. Basically, they want to make sure they consider compliance, they considered as of 12/31 a good compliance effort, or 100, hitting that compliance goal to be you showing good faith in establishing a 171 Clause 7012 program. Doesn't mean you have to have all those controls in place. It just means you have to have undergone the effort to assess your organization, and you have a good roadmap. You're making progress against that roadmap. So that's a little bit of a misunderstanding that they want to clear it up. Now, we've passed the deadline, so that perspective will shift from the DoD. That will shift over time as we move forward, especially for companies that have had the DFARS requirement for some time. They're going to start shifting their perspective to say, okay, well, as of 12/31, you needed to have, an in-progress effort. But really, as we get further into 2018, especially the latter half of the year, I think the expectation will be that you will be approaching 100% implementation. So it's not kind of a get out of jail free card here. And there's another myth too that we see a lot of kind of sketchy providers out there, and that say, oh, well, you can buy our software or you can buy our hardware and connect it to your network and you'll be compliant. Well, the problem with this is there's no way that software or hardware will get you to compliance alone. Now, certainly there are tools out there that help. You can't get there just through policies alone. You can't get there, with any one single facet. The problem is there's a lot of companies out there that, they'll charge you $5,000 for a piece of hardware or $5,000 for software. And companies are looking at that and saying, well, that sounds a lot better than me standing up a $20,000 compliance program, but it really won't get you there. I mean, you need to write your system security plan. I would be very skeptical of any solutions that spit out a system security plan automatically. It needs to be fully bespoke for your environment, and that plan of action milestones need to be fully bespoke for your environment. So there really is there's no one single magic tool software product that you can purchase that gets you there. It has to be a combination. And here's an example of, and this is a very complicated looking slide, but really what you have across the top are the control families, just abbreviated, and going down the columns are the specific control numbers. Now, this just gives you a sense of what's needed to approach, what approaches are needed to hit your compliance targets. And so you can see, with access control, that first column, getting fully compliant with the requirements in that column will require configuration changes. It will require a policy, written policy. It will require, in some cases, hardware, in some cases, software. So you can see here that there's really no one magic approach that will solve your problems. You need to stand up a compliance program that's comprised of key stakeholders, lots of different people involved who will be working on various aspects of this policy. Technical writers, IT administrators are obviously going to play a critical role here. And you may look to the vendor community, for log management software or security software, multi-factor approach. There really is no one magic solution here. So this slide sort of shows you what efforts are needed, to meet the compliance targets. The other equally important aspect of Clause 7012, we touched on this at the very beginning, is cyber incident reporting. This is a critical area in the eyes of the DoD, and it speaks to your ability to protect CDI and how capable you are to identify an incident, a compromise that either is actively occurring, had already occurred, or might be kind of in progress. The requirement is that you report this information to the DoD within 72 hours of you detecting it. And that's a pretty high bar, and it's a very difficult situation for a lot of small to medium businesses to be able to do that. I mean, the one thing is they've at least written the language so that you can, it's 72 hours from your detection, not thankfully 72 hours from when it occurs, because most system compromises have occurred for some time before they're noticed. I think the average is 6 months. But the expectation is there that you have to have a way to, you have to have a reasonably functional cyber incident process. So the requirement is there that you have adequate tools and processes to be able to identify cyber incidents in reasonable time. And the category is very broad, and it's any evidence of unauthorized logical or physical access to CDI. That could be through a breach of your network, could be through lost, stolen devices, a break-in of your office, anything in that broad category. And it's your responsibility to gather what information you can and report that within 72 hours. They will come back to you from there with further instructions, which is often additional records. If it's malware, they may want a copy of the malware. They will come back to you to give you further guidance on what information they want. But this is a very important area to the DoD. Now, another sticking point here that it's a bit peculiar, but they want reports in a very certain way. They want all incident reports to be submitted on the Dipnet, which is it's the Defense Industrial Base Network. It's a DoD website that, in order to even get to the website, you need to have a medium assurance certificate, special type of computer certificate that can take some time to procure. So this isn't something, if you have an incident today, without this certificate, you won't be able to submit within 72 hours. And even if you go out and buy that certificate, you probably won't have it within 72 hours. So this is another important one to be aware of, this requirement, to get out in front of it, to get that certificate, stand up a process to be able to identify cyber incidents as they're in progress. As I mentioned, though, they may come back and say, okay, so you've identified the breach, maybe it was yesterday. We're going to want, all firewall logs. We're going to want, Active Directory or domain level logs to show maybe where this person went within the organization, system level logs, whatever information you might have, bandwidth reports. They'll come back and ask for that additional data. But basically, in the clause, they're looking for you basically to kind of hit the record button and retain at least 90 days of data, relevant data, from the point of you noticing an incident and onward. So you have to be ready. This is why this is an important area that kind of needs to be not only documented in a process, but practiced a little bit, because you're not going to have a lot of time. And hopefully it doesn't happen, but if it does, it kind of needs to be muscle memory how you respond. And a lot of organizations don't have the tools, out of the gate, unless they've gone through this, or maybe there's regulatory requirements, but most organizations don't have log analysis tools, log collection tools. Maybe it's whatever the default settings are on their systems. But so this is an area that does require some work. One other caveat with compliance is to be careful of cloud computing. Now, cloud computing's been a big buzzword for the last 18 years, really. Most companies, you think about what's around us, right? Phones. We've got Google, the G Suite. We've got Azure, Office 365. Most companies have a cloud product. We're using the cloud in a lot of cases unintentionally. There are some big stumbling points here with DFARS. You are only allowed to use cloud products that may store or process CDI if the cloud provider is FedRAMP authorized at the moderate impact level. Now, it sounds complicated. There's a very easy way to find out whether your cloud provider is on this list. You go to that link, marketplace.fedramp.gov, and filter based on moderate impact, and you'll have your list. It's not a big list. It's a very small list, actually. We've been in situations where our clients are using a cloud backup solution, Carbonite as an example, backing up their systems to the cloud, systems that contain CDI. That is not authorized under DFARS. So that activity needs to be stopped immediately. There's only really a few providers that are FedRAMP authorized at this level, so you really need to be careful. A lot of organizations that are subject to DFARS just choose not to use cloud products because it introduces too much uncertainty. So something to be very cognizant of. Another area of concern here is the Flowdown Requirement. So let's say you've gotten to the point where you're reasonably compliant, and you yourself have subcontractors in the chain that may store and possess covered defense information. You are required to flow down these same requirements to your subcontractors. A lot of organizations kind of forget that, like, okay, we finally hit our compliance targets after, however many years of effort. Well, it doesn't end there. Really, as you stand up a compliance program, you need to flow these requirements down to those under you, your subs on the contracting chain. It's very important. And similar to that, you are required. So all the data you get should be marked CDI. It should be clear. If it isn't, you need to clarify with your contracting contacts, either at DoD or at the primes or higher up on the contracting chain. You are also required to mark your own data that's generated in performance of the contract as CDI. So if it's part of the work you're doing in performance of a contract, there's a very good chance that the data that you're generating would be considered CDI. You have to be, you're responsible for marking that data. And if you provide that data to subcontractors of yours, you have to make sure it's marked before it gets to them, and the requirements, all of these requirements flow down to them as well. So that needs to be clearly communicated, especially if you're dealing with very small subcontractors. You're really putting quite a burden on them, and that may influence your decision on which subcontractors to go with. Okay, the deadline is passed. We know that, right? 12/31/17 was the deadline. Where does that leave us? Well, in short, it doesn't leave us in a good spot. If you have undertaken no compliance activity and you're submitting invoices against a contract that has the DFARS 7012 requirement, you may be committing fraud, okay? The DoD has come out and said this. Many law firms have come out and said this. You may be subject to charges under the False Claims Act, because the contract language says if you're performing this work, if you've signed this contract, you agree to the terms and conditions of DFARS Clause 7012, which say you need to stand up a compliance program by 12/31. If you haven't done that and you're submitting an invoice, you're falsely claiming to be compliant. And that's an offense that can be prosecuted. So it's pretty serious. And the other area, talking about the enforcement side of it, right now, there's the primary means of enforcement is going to be on the procurement side. If you're bidding on work with the DoD and to primes as well, primes can interpret this in different ways, but if you're bidding on work with the DoD, they're going to say, along with your proposal, submit your system security plan. So right there, if you don't have one, you're going to be essentially eliminated from winning that contract. So what should you do right now? Well, I think if you haven't done anything, you should immediately review the 110 requirements. Quickly go through. Can you, in-house, can you start a program? Do you have the expertise to review the 110 requirements? Maybe you don't have technical people on staff, but really the first step is to determine what's in place already, what's not, and what you need to do to get those in place. If you look at this and you're just overwhelmed, you need to reach out to a third party that can assist you. The key is not to procrastinate. If you're newly subjected to the DFARS requirements, you say you get a contract in today, you need to go through within 30 days of the contract award and determine what areas you're non-compliant in and communicate that back to the DoD and to your prime or whoever is higher up on the chain. And then you kick off a groundwork compliance effort. And then you start the process of building the system security plans, documenting the POAM. A lot of questions we get, is will I be audited? The short answer is no. It's a self-assessment, but procurement will be the primary way that non-compliance is weeded out. If you don't have a good system security plan, you will likely be disqualified from winning the work. But primes have a much more flexible situation. They can choose sort of the terms and conditions that you have to adhere to do business with them. And it could be more stringent than what you get from the DoD. And as I mentioned, misrepresenting your compliance may be an offense that can be prosecuted. All right, so getting to the last phase here, the last few slides, we're going to talk a little bit about cost. Now, quickly, I mean, it's difficult to say what the cost will be because, you could be a company of 5 people or a company of 500,000 people. It's largely up to sort of the solutions you put in place, whether or not you need help from a third-party assessor. It varies. We usually see some of the more expensive areas around multi-factor authentication. So, an approach, a solution for that might be smart cards. They look like credit cards. You put them in a reader. Each card is assigned to an individual. And in addition to your username and password, you need a card to log in. Could be those kind of look like USB. There's a brand called YubiKey. There's a number of solutions, but it's expensive to procure those and to configure the software on the back end. FIPS encryption, this is it's a technical control here, but some of your existing technology might not be good enough to meet the encryption requirements. So you might need a whole new VPN solution. That could be expensive. Software that allows you to whitelist and blacklist, maybe you don't have that. You'll have to go out and buy it, or maybe you could get by with some open source software. Audit log review software, all these things cost some money. We typically see small to medium-sized businesses spend between $15,000 and $50,000 on their compliance program. Now, this is a very broad range, but just general guidelines. That will include assessments, documentation, configuration efforts, new software and hardware. And we typically work with companies that have, anywhere from 5 employees up to 10,000 employees, generally in that range. And this is what they're spending to get that initial compliance program off the ground. So where we fit in this, we're a CPA firm at heart, and I head up the DFARS program within our IT audit and security practice. We're product agnostic advisors. We don't resell any technology, you know, we don't resell any software. We perform objective third-party assessments of where you are against the requirements. We write, you know, we've got great technical writers. We'll write your system security plan, your plan of action and milestones, cyber incident process. We train your staff. We work with you to stand up a program. And we also guide you through the remediation phase. So not only telling you what you have and what you don't, it's how do you get to compliance? What settings do you need to change? What technologies do you need to implement? And then we'll come in and perform the final assessment, which is, did you meet the remediation efforts? Did you achieve compliance? Okay, then if you did, let's document all of that in your system security plan, your POAM, your cyber incident policy, and then, you know, we'll provide kind of the rest of that documentation to meet your compliance bundle, you know, all the acceptable use policies, controlled unclassified, CDI policy, which is really about handling the material. And one major thing to note is once you achieve compliance, you're not done. This is meant to be a continuous effort where you have to come back in and reassess everything that you've done, reassess your system security plan, reassess your POAM if you still have one, reassess all your policies and procedures on a continuous but at least annual basis, or after major organization changes, you know, maybe departmental reorganizations, mergers, acquisitions, sales, you know, you name it, any kind of major organizational change that has to be reassessed. That is the end of our main segment. I don't see any questions in the chat, but one that does come up is the sort of the right to audit. We work with a couple prime contractors that are now rolling out, and as I mentioned, primes have some flexibility in terms of how they can enforce these contracts. So what we're seeing is prime contractors coming out and standing up their own right to audit programs. So any subcontractors under them can expect to undergo an audit of some kind. You know, usually the information assurance teams at these organizations are kind of building out their assessment programs and will perform some sort of activity to determine whether or not those subcontractors under them are complying with 800-171. So that is something. If you're working with a big prime, you can be sure to expect some kind of approach. Maybe it's not a full-on audit, but they will ask you to demonstrate compliance. So you can expect that. All right. Well, looks like that's it for questions. Our contact info is up on the screen. My contact info is there as well. You can visit our website, ocd-tech.com. We have lots of resources related to DFARS. It's something we blog about regularly, so check out our blog page. And definitely reach out to us and let us know if we can be of assistance. Thanks for attending.